If you're the victim or a witness in a crime and you don't want to go to court, but you get a subpoena, do you still have to show up? I get that question a lot, but I think a better question is what happens if you don't show up to court? And now that really depends on how you receive the subpoena. If you get a subpoena from a police officer, a sheriff, a constable, somebody actually serves it to you in hand, and you don't show up for court, what will likely happen is the person who served you, maybe the prosecutor, will tell the court that they have proof of service. They have a person identifiable who can swear out an affidavit that you've been served in hand. And if you don't show up and you have that proof that you were served in hand, then the judge could order that the police can come and pick you up and bring you to court. Now, if you have received it by mail, which often happens, mail, email, some other way where there's not really a proof that you actually received it, then what happens is if you don't show up to court, the prosecutor could ask for a continuance, meaning they could ask for another date so that they can then perfect the service, meaning they can then get somebody to actually serve you in hand before the next subsequent court date. Or in practice, for a lot of cases, especially if it's like a minor domestic violence allegation, a lot of times what happens is the prosecutor will look out in the courtroom, they'll call out the name of the person who was subpoenaed, and if they don't show up, the case gets dismissed. So it really depends on the circumstances. If you have questions about your circumstances, you should obviously talk to a lawyer. This isn't legal advice, but generally that's what happens in practice.